been tried and raised, no, canvas is not novel. See Duke Mabea and A against the governor of Abba Hill Prison and application. First is that once a law was convicted under a law that is later declared unconstitutional and has either exhausted the appeals, or has not pursued an appeal, the matter is taken to have been concluded. In such circumstance, the declaration of unconstitutionality of the law as between even prospective or retroactive effect should be determined at the time of that decision, as this one here now. Thus, there is a further difference between criminal cases on direct criminal cases where the person seeking is being convicted but is still pursuing a direct appeal, while collateral review refers to those cases where the criminal defendant has exhausted all direct appeals, if any. I cite the authority responsible. American jurisprudence case, and the court cited this and came to the conclusion that retroactivity should depend on, one, the purpose of the new rule, two, the extent of reliance on the new rule, three, the effect on the administration of justice of the retroactive application of the new rule. The decisions following link letter laid down how this rule would apply to pending cases and those on appeal under direct review. The current American position elucidated in an annotated constitution prepared by Congressional Research Service at the Library of Congress and quoted in A against Governor of Abba Hill Prison stated as follows, open quote. The court has now drawn a sharp distinction between criminal cases pending on direct review and cases pending on collateral review. For cases on direct review, a new rule for the conduct of criminal prosecution is to be applied retroactively to all cases, state or federal, pending the direct review or not yet final. Thus, for collateral review in federal courts of the state courts, criminal convictions, the general rule is that new rules of constitutional interpretation announced after a defendant's conviction has become final will not be applied. Thus, application for habeas corpus based on a judicial decision subsequent to a conviction becoming final and not otherwise under direct appeal or review fall into the category of collateral review and therefore not entitled to rely on new rules of constitutional interpretation. This principle is apparently not novel to our modern time, as Cicero is credited with having coined the maxim, summum ius summa iniuria, variously translated but classically as the strictest application of law is the greatest injustice. This general principle regarding the effect of declaring a legislation unconstitutional was succinctly stated by Murray J. in A against the Governor of Abba Hill Prison as follows. In a criminal prosecution, where the state relies in good faith on a statute in force at the time, and the accused does not seek to impugn the bringing of or conduct of the prosecution on any other grounds that may be in law, open to him or her, including the constitutionality of the statute before the case reaches finality, on appeal or otherwise, then the final decision in the case must be deemed to be and to remain lawful, notwithstanding any subsequent ruling that the statute or a provision of it is unconstitutional. The learned CJ explained the meaning of a collateral attack as follows. A collateral attack arises where a party, outside the ambit of the original proceeding, seeks to set aside the decision in a case which he has already been finally decided, all legal avenues, including appeal, having been exhausted. For reasons that were not raised in the original proceedings, but for reasons arising from a later court decision on the constitutionality of a statute. He made a comparative survey and review of various jurisdictions on the issue and found commonality in the decision taken by them on it. He then said, the question of retrospectivity in the form raised here is one which is material to all legal systems. The fact is that at no stage during the course of the hearing of this case was the court's attention drawn to any system of justice in which a finding that a law is unconstitutional, even where this is deemed to be so ab initio, meant that previous and final judicial decision based on such a law must inevitably be considered unlawful and of no effect in law. I'm not aware of any legal system to that effect. Referring to the situation obtaining in the U.S., said there are transcendent considerations which militate against complete or absolute retrospectivity. Fundamental interest of public policy requires limitation on the retroactive effect of judicial decisions. The legal order and the administration of justice is not one perfect symmetry. As Justice Benjamin Cardozo observed at page 161 in his seminal work, The Nature of the Judicial Process, Yale University Press, 1921, we like to picture to ourselves the field of the law as accurately mapped and plotted. We draw our little lines and they're hardly down before we blur them. Although judicial adjudication do not have retroactive effect, there are important exceptions and restrictions to that effect. A line must be drawn in the interest of justice. The CJ further elucidated on the matter thus. A judgment condemning a statute for being inconsistent with or contrary to the Constitution does not mean that all which was done or decided under the statute prior to the decision on constitutionality is in all circumstances void and of no effect. It is a principle which is, for reasons indicated in the various judicial dicta which I've cited, consistent with the Constitution as a whole. The common law dimensions of our legal system and the legal system of many other countries in which the courts have the same or an analogous power of judicial review of the validity of laws. Then he said, certainly issues concerning the constitutionality of statutes are on a plane higher than the mere common law. They concern questions fundamental to the rule of law, the protection of rights, and the very framework within which, in the words of the preamble of the Constitution, true social order is attained. Normally, those fundamental constitutional concepts, such as the rule of law, individual rights, justice, and a social order based on that rule of law, blend together so that the principles of constitutional justice to be applied to resolve issues may be readily deduced. On other occasions, some of those considerations may be competing or even conflicting ones, where the courts have to balance those different interests so as to do justice within the framework of the Constitution. In this instance, one may say in broad terms that there is a competing interest between the claim by the applicant that he stands convicted under a law which has subsequently been found to be inconsistent with the Constitution as from 1937, and the interest of justice, including the rights of the victim, where he was otherwise lawfully convicted of unlawful carnal knowledge of a 15-year-old girl, in circumstances where, as his counsel acknowledges, the conviction and sentence were not tainted by any want of fairness or injustice. Thus, the effect of absolute retroactivity, for which the applicant argues, in a sense raises competing consideration, which the court has to address having regard to the provisions generally of the Constitution and what Henchy J. alluded to as transcendent constitutional consideration, the public interest, the common good, and social order. In response to the argument that the declaration that a law is unconstitutional, the learned CJ had this to say: absolute retroactivity based solely on the notion of an act being void ab initio, so as to render any previous final judicial decision null, would lead the Constitution to have dysfunctional effects in the administration of justice. In the area of civil law, it would cause injustice to those who had accepted and acted upon the finality of judicial decision. Rights which had become vested in third parties as a consequence of such decisions would be put in jeopardy. The application of a principle of absolute retroactivity consequent upon a declaration of unconstitutionality of an act in the field of criminal law would render null and of no effect final verdicts or decisions affected by an act which at the time had been presumed or acknowledged to be constitutional and otherwise had been fairly tried. Such unqualified retroactivity would be a denial of justice to the victims of crime and offend against fundamental and just interests of society. I find these authorities quite persuasive and applicable to the current situation because the constitutional rules declared touch on the fundamental aspects of a criminal trial in a democratic dispensation. In the present case, we have those who have been charged, those undergoing trial, those convicted and in the process of challenging such conviction, as was the case in the Lieutenant Ogwang case supra, and those whose conviction is final. This is the situation of obtaining with regard to those who have been defendants in the courts martial. I consider that the first three categories that fall under direct review can without any difficulty take benefit from the rules expounded herein as regards trial in the courts martial. However, for those whose trial is completed or who are also referred to as those on collateral review, it is my considered opinion that they fall within the exception enunciated above. In the event, I would make the following declarations. 1. The Summary Trial Authority, STA, and the Unit Disciplinary Committee, UDC, are respectfully, lawfully established under sections 191 and 192, now 189 and 190, and section 195, now 193, of the UPDF Act as military tribunals. 2. The provision of section 197, now 195, of the UPDF Act establishing the General Court Martial as a competent court is constitutional. 3. The General Court Martial created under section 197, now 195 of the UPDF Act is a subordinate court of law but with specialized jurisdiction. 4. The provisions of section 179, 1 and 2, now 177, 1 and 2 of the UPDF Act, read together with section 197, 2, now 195, 2, which grant the subordinate military court's jurisdiction over capital offenses contravene Article 129, 1D and Article 126, 1 of the Constitution, hence they are unconstitutional. 5. The provisions of section 191.3, which is now section 189.3a, and section 195.3 and 4, now 193.3 and 4, read together with section 179, now 177 of the UPDF Act, which grants this STA and the UDC the exercise of judicial power of detention and imprisonment of any person tried by them, contravene Articles 23, 126, 1, and 129, 1D of the Constitution. Hence, they are unconstitutional. 6. The provisions of the UPDF Act constituting and providing for the trial procedure of the General Court Martial, the Division Court Martial, and the Court Martial Appeal Court do not contain any or sufficient constitutional guarantees and safeguards for them to exercise their judicial functions with independence and impartiality, which is a prerequisite for fair hearing provided for under Articles 21, 28.1, 44C, and 128.1 of the Constitution. The provisions of Section 1191G, now 1171G of the UPDF Act, under which the respondent, a civilian, was charged and arraigned in the General Court Martial, contravenes Article 28.1, 44C, and 21 of the Constitution. Hence, it is unconstitutional. The provision of Section 1191G, now 1171G, is unconstitutional to the extent that it permits trial in the courts martial of civilians who have allegedly aided and abetted the commission of a crime, of a service offense rather, or ordinary criminal offense in which a person subject to military law is a principal offender. 9. Sections 2, 179, 119, 1H and G, now respectively sections 1, 177, 117, 1H and G of the UPDF Act are unconstitutional since they confer blanket jurisdiction on courts martial to try civilians. The jurisdiction conferred by Section 2, 179, and 191 1H, now sections 177, 117, 1H of the UPDF Act on the General Court Martial to try persons subject to military law for civil and non-disciplinary offenses committed in Uganda is unconstitutional, as they contravene Articles 209 and 210 of the Constitution. I would accordingly propose the following orders. The declaration of the Constitutional Court that Section 1191G, now 1171G of the UPDF Act, which provides that any person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense is constitutional, is hereby set aside. All charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred. Order. I'm going to chase you out. This is not cloud 9 where you can... So I said all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. 3, this judgment, you just note, don't stop this clapping thing. This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law. All pending trials or partly heard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. 5, save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. The cross appeal is hereby allowed. The respondent is entitled to the cost of this appeal and in the Constitutional Court. I'm going to empty the court and I read the judgment without any of you. Just try me again one more time and you'll see. Advisory order. This court is giving an advisory order to the executive and parliament. An advisory order is an advice which is slightly stronger than an ordinary advice. That's why it is called an order. Does not bind but it will be foolhardiness if you do not pay attention to. That's really what it is. You may not take it, but at least you give it consideration. That's why in law, it's called an advisory order.
At times it is called an opinion, but it is an order, non-justiciable, but it is nonetheless an order. Court-martial are not unconstitutional merely by their very nature of being military courts. The people of Uganda pronounced themselves in the course of the making of the 1995 Constitution, expressing their fervent desire to make a break from the ugly past that characterized life in our country, especially the grave abuse of human rights by the military. The Ugandan military has since been transformed into a professional force, and it has made remarkable contribution to ensuring regional peace, security, and stability. It is rather contradictory
and rather disconcerting for a military force built on new and commendable professional dispensation
to operate under the same legal framework that failed to check or avert military abuse of power with unspeakable ramifications. The 1995 Constitution provided the new wine, which the UPDF Act, as instead through the impugned provisions of the Act, sought to store in old wineskins, as it were. This is a blatant negation of the aspirations, desire, hope, and wishes of the people of Uganda, which the framers of the 1995 Constitution meticulously enshrined in no uncertain terms in the Constitution. It is noteworthy that in Uganda Law Society against and Karugaba against the Attorney General, the Constitutional Court observed that the Constitution was unfortunately being ignored and recommended that Parliament could amend the Constitution to provide for any special needs of the military. It said, open quote, the UPDF is currently being operated under laws and practices which still contain colonial relics in total disregard of the Ugandan Constitution. No attention was paid to this problem when drafting the 1995 Constitution. This court has no powers to bend the Constitution in order to accommodate special needs, whether legitimate or not, of the army. It is only Parliament that has the power to amend the laws, including the Constitution, to accommodate such special concerns of the army. So far, it has not done so. I must therefore stick to only such interpretation of the law that is consistent with the Constitution as it stands now, close quote. The current military courts operate in violation of the constitutionally enshrined and securely protected rights to a fair hearing that are equally recognized universally in conventions and other instruments. Thus, there is need for a robust legislative intervention to ensure the UPDF Act is in accord with the cherished aspirations of the people of Uganda, as was unmistakably captured in the Docker Commission report. In the full judgment, I actually reproduced so much of that report extensively. It is therefore incumbent on the executive to generate the policy and Parliament to pass the legislation which addresses and cures the injustice occasioned by the unconstitutional provisions of the UPDF Act, which have now been quashed by providing for military courts that are clothed with the constitutional safeguards of independence and impartiality that are accorded to ordinary courts. In recognition of the special nature of the military, legislation must be put in place that establishes and confers on the courts martial and tribunals the powers to execute lawful jurisdiction over members of the military, and thus fulfill the function of the UPDF. However, this special exercise of jurisdiction must not infringe on the soldier's right to a fair hearing. The state needs to act in order to ensure that the character of military courts and tribunals meet the democratic standards and aspirations of the people, which are clearly enshrined in the Constitution. It is noteworthy that the court advised in 2009
Uganda Law Society against Karugaba, that the military courts to be truly independent and impartial, there are desirable changes that the executive needs to address it noted as follows. In order for this to be applicable to the military courts, the article would have to be modified in such a way as to give the courts independence and impartiality without compromising their military nature. The army would have a parallel judiciary with legally trained soldiers to professionally man the courts. In order to be impartial, the court must have security of tenure and other privileges enjoyed by the other judicial officers in the Ugandan judiciary. It should be noted that the definition of judicial officer contained in Article 151 does not exclude persons exercising judicial power in military courts, close quote. I consider the need for this recommended transformation as relevant today as it was then. In the premises, I would make the following recommendations for consideration by the executive and parliament as viable alternatives for the establishment and or creation of military courts in Uganda. These are recommendations. They can pick any, they can reject all, but these are recommendations which the people of Uganda hope they will look into. A, administratively establish the General Court Martial as a division of the High Court without the need to create a new court, with jurisdiction to handle capital criminal cases involving both military officers and any civilians who would exceptionally fall within its ambit, with magistrates within the division handling offenses falling under their jurisdiction. B, limit the functions of the unit disciplinary committees and summary trial authorities to handling strictly disciplinary offenses with no power of imposing sentences or imprisonment. C, utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offenses committed in Uganda, which are currently falling within the docket of the UDCs. The subordinate military courts can handle criminal cases at the level of Chief Magistrate's Court for offenses attracting life imprisonment and below. Or D, with the advice of the Judicial Service Commission, appoint civilians with the requisite professional legal qualifications to serve as judicial officers in the current subordinate military courts. They would exercise jurisdiction over offenses triable by the subordinate courts. They should have the same privileges and safeguards as their counterparts in the civil courts. Or E, amend the Constitution to establish superior courts within the military court system under Article 129 and clothe them with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses of a capital nature and all other capital offenses under existing laws committed by military personnel. Or F, provide in the UPDF Act for the High Court to sit as a court martial with power to try all criminal capital offenses within the High Court jurisdiction, and those unique to the military that attract a maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can act as assessors. Appeals to the court-martial appeal courts would follow the same format, with the Court of Appeal sitting as such. Magistrates' Court would assume the jurisdiction over all other offenses of a subordinate court. G, make provision in the UPDF Act for trial of civilians in military courts to be only under limited circumstances and only if the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. This must not only apply where in relation to specific class or category of persons and offenses,
in question
not in position to undertake such trial. H. Make provision in the UPDF Act for appeal from military courts and tribunals corresponding to appeals in the ordinary options suggested above. The jurisdiction of UDCS and STS must be limited to that of tribunals, handling strictly disciplinary offenses with no power of detention or imprisonment, as is the case with other disciplined
forces, such as the police and prisons. Dated Kampala this 31st day of January 2025, Alphonse C. Owindolo, Chief Justice. Now, since my brothers and sisters agree either unanimously or by majority concurrence of the orders proposed in this judgment of the Chief Justice, orders are hereby accordingly given in the terms proposed by the Honorable Chief Justice according to that ratio. Judgment is delivered in Kampala this 31st day of January 2025. And as I said, we intend to avail you the soft copies of the judgment by close of business today.
Of the Supreme Court, on behalf of the respondent, we thank this court for this bold decision, and at the same time, as a senior lawyer, we also seek for forgiveness for some lawyers' practice
and utter issues they do not understand, which tend to undermine the essence of this court. My Lord, we are sorry on behalf of Uganda Law Society, but otherwise we are so grateful for the bold step this court has taken, and I think we have no way of expressing it. Thank you, my Lord. Much obliged.
My Lord, for my clients who expected to go to the General Court Martial.
Who are your clients?
Councillor
Alaka?
And the Lord Mayor, who was sentenced to 1,000 shillings in the General Court Martial. They will miss out on claiming.
The Lord Mayor. That's why he's not dressed as a lawyer today. he thinks I was going to jail him.
We're only grateful, my Lord.
You know, this is now, we are done. One time he invaded me here. Lord Mayor, when you invaded me with journalists and some stranger lady, I had gone to the Kitezi site to see how an irresponsible administration of a city can cause such misfortune. That's why you did not find me here. I'd gone to Kitezi. Yes. So it's okay. You can go. Yeah.
5 in the revised version of the laws of Uganda, of the Uganda People's Defense Forces Act. Its long title reads, among other things, that it is an act, I'm quoting, to provide for the regulation of the Uganda People's Defense Forces
in accordance with Article 210 of the Uganda Constitution and for other related matters. It is a specialized court in the sense that it was created to exercise jurisdiction over specified matters relating to offenses created by the UPDF Act, committed by members of the military forces and persons who aid or abet such offenses. In short, to administer military justice in Uganda with jurisdiction to handle offenses specified in the Act, mainly for penal and disciplinary purposes. The General Court Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Cadi's courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament. 2, the Supreme Court, the Court of Appeal, and the High Court shall be superior courts of record and shall each have all powers of such court. And 3, subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, the courts martial are set up by an act of Parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial, set out under Section 195 in the revised version of the Laws of Uganda 2023 of the UPDF Act, is that they should essentially be army officers, with the chairperson not being below the rank of a lieutenant general. Save for the chairperson of the court, of the Court Martial Appeal Court, who is required to be an advocate, qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military courts set up under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified persons qualified for appointment as judicial officers to the courts of judicature as established under Article 129 of the Constitution of Uganda must have legal qualifications. It is to be noted that both the General Court Martial and the courts of judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law would pass. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court martial. The contradictory position is that while under the UPDF Act, qualification for appointment to the General Court Martial does not require one to have legal qualifications, persons qualified for appointment to the position of a judicial office in the courts of judicature are required to have legal qualifications under Article 142 of the Constitution. Secondly, the conducting of criminal trials in the General Court Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications.
Well, that was Lady Justice Passed Night to Haise, and of course giving her own ruling. Now, 4 judges, Justice Monica Mujenyi, Catherine Bamgemerere, Elizabeth Musoke, and Mike Chibita, have so far pronounced their judgments. Now, Justice Catherine Bamgemerere has, in her own ruling, suspended all the proceedings ongoing in the General Court Martial after finding it inconsistent with the Constitution. She has called for the amendment of the UPDF Act. Now, in recent weeks, activists have been intensifying their call for the Supreme Court to resolve this issue, the contentious issue of trying civilians in military court. So today the Supreme Court is delivering the ruling, and we are hoping that as we have a big legal representation there from the Ministry of Justice, we know that we will have a resolution there. Now let's hear more from other judges there and other judges there in the justice system, and we see what's going on.
Out in detail and the judgment of the Honorable the Chief Justice, which I've had the opportunity to read in draft. I also had the opportunity to read the draft the judgment of the judgment of Ogenyi, Justice of the Supreme Court. And in the interests of brevity, I'll straight away go into a discussion of the findings in my judgment. However, before giving my views, I should say that when the respondent filed his petition on 17th November 2016, he was challenging certain provisions of the UPDF Act of 2005. Under the 2023 revised edition of the laws, where the UPDF Act is now Cap 330, the numbering of many of the impugned provisions has changed, as indicated in the judgment of the Honorable, the Chief Justice. Nonetheless, in this judgment, I make reference to the numbering of the relevant provisions as set out in the respondent's petition and the judgment of the Constitutional Court. Although for future purposes, the numbering contained in the revised Act should apply. My judgment, and I said I'm giving a brief, a summary of it. As I have indicated in my judgment, which you'll get, the grounds of appeal and cross-appeal, in my view, raise the following questions for this court's determination. Whether the 1995 Constitution places limits on the jurisdiction that Parliament can confer on the General Court Martial and the other military courts, and if so, what is the scope of those limits? Whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond the applicable constitutional limits. Whether the General Court Martial is a subordinate court within the meaning of Article 129(1)(d). Whether the General Court Martial had jurisdiction to conduct the arraignment of the respondent, and if so, whether the arraignment contravened the respondent's right to a fair trial. Whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44(c). And lastly, what are the appropriate remedies to grant in this case? My perspective on these questions is as follows. The first question being on regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that the 1995 Constitution under Article 2010B limits the jurisdiction that Parliament may confer on any military court to only matters falling within the sphere of discipline and removal of members of the UPDF. This implies that the nature of cases that may be tried by the military courts are limited to disciplinary offenses committed by members of the UPDF, and the nature of punishment that can be imposed for such offenses is limited to the disciplinary sanctions, which are also provided, which are dismissal with disgrace, reduction in rank, forfeiture of seniority, suspension, severe reprimand, and caution. So for the analysis of the first question, you'll find that analysis on pages 2 to 10 of my judgment. Second question, in relation to the second question of whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond any applicable constitutional limits, I find that it does in many respects as follows. First, in respect of Section 2 and Section 119(1)(a) to F of the UPDF Act, which conferred jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offences under Part 6 of the UPDF.
Justice Elizabeth Musoke as well giving her ruling. We still also have others like Mike Chivita pronouncing their judgments on this specific ruling. But overall, it looks like every ruling determines that military specific offenses should be against military personnel. Right now, we are crossing over to the Supreme Court, where we head back to the session as we hear the ruling on whether civilians should be tried in the military courts.
Analysis and the decision made. I also concur with the proposed orders as embodied in his lead judgment. I have nothing useful to add. Signed by Lady Justice Faith Monda. So this is the summary of my judgments. Here I will not read everything. I'll read the core part of the summarized judgments. So it headed summary of the judgment of Owindolo CJ. It's not Owinyi, it is Owindolo. Introduction. This appeal arises out of a petition instituted under Article 137, Clause 1 and 3 in the Constitutional Court. In essence, the appeal and cross-appeal are against the majority decision of the learned justices of the Constitutional Court regarding the competence of the military courts, their ability to render a fair hearing, the offenses triable in military courts, and persons subject to the jurisdiction of the military courts in Uganda. The background. When he filed constitutional petition number 45 of 2016 in the Constitutional Court, the respondent was a civilian and member of parliament representing the people of Nakawa Municipality, Kampala Capital City Authority, KCCA, in the 10th Parliament, and a shadow minister for KCCA. He filed the petition against the backdrop of events following his arrest, where he was arraigned before the General Court Martial, GCM, and charged along with others with offenses under the Uganda People's Defense Force (UPDF) Act. To wit, offenses relating to security, contrary to Section 130, subsection 1, paragraph F, with the particulars thereof being that he contrived a plot with others to overthrow the government of Uganda, and treachery contrary to Section 129A, with the particulars thereof being that he infiltrated the UPDF or was an agent of a foreign power or any force engaging in war or warlike activities against the government of Uganda. He objected to his trial in the GCM, contending that he was not subject to military law as he had no military connection, and that the GCM was not a competent court under the Constitution to try any of the offenses with which he was charged. But the GCM overruled his objection. He filed a petition in the Constitutional Court challenging the provisions of the UPDF Act number 7 of 2005, which he singled out in the petition, and acts of the UPDF of arresting, detaining, and remanding him to prison in relation to the charges against him, as being inconsistent with the Constitution. The proceedings in the GCM against the respondent were stayed by an order of the Constitutional Court. He prayed for a permanent injunction to restrain the appellant from continuing those proceedings. The Constitutional Court partly allowed the appeal in its majority decision, where it inter alia held that as a civilian, the respondent was not subject to military law and could only be lawfully tried by a military court if he were charged under Section 119, subsection 1, paragraph G of the UPDF Act as an accomplice to a principal who was subject to military law. And the principal was so named in the charge sheet. There being no principal named in the charge sheet, the court held that the charges brought against him were null and void and of no effect. The court also declared Section 119(1)H of the Act, which allowed military courts to try persons for offenses provided for under other laws outside the scope of the UPDF Act, unconstitutional. According to the court, Parliament never intended that the UPDF Act should be an act of general application, since it is a statute of special and limited application. Hence, the unlimited and original jurisdiction of the GCM referred to in the UPDF Act only apply to offenses under the Act. Last, the court examined the nature of the military courts and held that first, military courts lack all the tenets of an ordinary court established under Chapter 8 of the Constitution, particularly under Article 28(1). Second, they are tribunals, and third, they are not part of the judiciary. The court accordingly ordered the petitioner to be released forthwith. The appellant was dissatisfied with the decision of the Constitutional Court, hence it appealed to this court. The respondent, for his part, cross-appealed against the decision, allowing civilians in certain cases to be tried in the military courts. The grounds of appeal are: 1, the learned majority justice of the Constitutional Court erred in law in finding that Sections 2 and 179 of the UPDF Act are in contravention of Articles 28(1) and 44C of the 1995 Constitution, and that the GCM is only competent to try military disciplinary offenses under Part 6 of the UPDF Act. 2, the learned majority justice of the Constitutional Court erred in law and fact in determining that the GCM cannot be impartial or independent, is inconsistent with Article 28(1) of the 1995 Constitution of Uganda, and does not apply the principles therein to persons subject to military law. 3, the learned majority justices of the Constitutional Court erred in law and fact in determining that charging and arraigning the petitioner before the GCM was inconsistent with Article 28(1) and 44C of the Constitution. 4, the learned majority justices of the Constitutional Court erred in law in finding that Section 119(1)H of the UPDF Act is inconsistent with Article 28(1) and 44C of the Constitution. The appellant prayed that the appeal be allowed. The decisions of the learned majority justices of the Constitutional Court cited be set aside, and the appellant be awarded cost of the appeal. The cross-appeal. The respondent cross-appealed on the following one ground: that the learned majority justices of the Constitutional Court erred in law in holding that a civilian can be charged before military courts as an accomplice together with a person subject to the decision of the majority justices that he has impugned be set aside or reversed. Consideration and determination of the appeal by this court. The appeal first came up for hearing in this court in 2022. From that time to its final disposal today, it has suffered an unprecedented affliction by a host of adversities. There is thus an imperative need to clarify on what transpired within that period. The grave and persistent series of events that characterized the lifespan of this appeal began with the fire gutting the chambers of the Chief Justice on the Supreme Court building at Kololo on the 27th April 2022, followed by water flooding parts of the building. This resulted in a condemnation of the Kololo Supreme Court building as being unfit for occupation, thereby leaving the justices of the court with no office accommodation. Thereafter, two justices of the court, namely Justice Paul Mugamba and Justice Ezekiel Mwanguzi, who were part of the original panel for this appeal, retired. This therefore necessitated a reconstitution of the panel. In November 2022, the court was able to secure a temporary home and more justices were appointed to the court. The court then embarked on the process of reconstitution of the panel with a view to sitting by December that year to rehear the appeal. However, that December, we suffered the devastating demise of Honorable Justice Ruby Awere Opio, who had been on the original panel for this appeal. This necessitated awaiting the appointment of additional justices of this court for the requisite reconstitution of the quorum to take place. However, in only 6 months thereafter, yet another tragedy struck this court with the demise of Justice Stella Arach Amoko in June 24, when 2 more justices were appointed to the Supreme Court. Whereafter, the court was able to reconstitute the panel for this appeal. The appeal came up before the reconstituted panel on 13th May 2024 in the new Supreme Court building at the Judiciary Headquarters, upon which the learned justices reserved judgments to be delivered on notice. Notice has been served on the parties for delivery of the judgment today, and that's why you are here. So the delay in this case did not take 4 years, as some